Hello and welcome to Property Matters. I'm Stephen Galpin, and today we're going to be talking about the new Leasehold Reform Act. And to join me on this is Chris Barry, Business Development Director of Thomas Legal. Welcome to you.
Thank you for having me.
Great stuff. Well, let's get right into this. The Leasehold Reform Act is something that we were going to see a couple of years ago. Has been postponed, possibly through an election, and now been put off again in terms of implementation till perhaps later this year, which smacks to me of next year.
Yes.
But there we are. First of all, Chris, I wonder if you could just run through some of the key elements of this act and who it's going to affect.
Yeah, sure. So the first stage has already come into force in January this year, which was the eradicating the 2-year rule that gives you the right to apply to extend your lease. That is now gone, so you can own a property within a 2-year period and automatically have the right to extend. So that's positive. The other areas that are likely to come in over the next couple of years will include things like not paying ground rent, and they're talking about abolishing marriage value, which is something that applies to leases that drop below 80 years. Normally, the freeholder shares in the value of the uplift to increase that back up. They're talking about increasing all leases to 990 years. And the sort of buzzword on the campaign trail was abolishing leasehold. Now, I think people took that on face value and thought, well, how are we going to abolish leasehold? We have thousands of leases in this country, some of which are hundreds of years old. How would we just say to that freeholder, we're abolishing the lease? It doesn't work. And now Labour have come out and said, well, actually, no, we didn't mean we're going to abolish all leases. What we meant was that we will get rid of leasehold houses, and that will come in over the next couple of years. And then eventually, and if you look at the website, they're talking sort of 27 onwards, they will not have the creation of new leases. And that will be a 10-year, possibly common hold, whereby the people that are in the building own the building. Very much like
so the subtlety of the difference will be, whereas you have a freeholder that holds the head lease and does a sublease for the long-term tenants, this is going to be common hold, which is going to be in the gift of the actual tenants themselves.
Yes.
Yeah.
Yeah, that's right. And what fascinates me really is that I've spoken to lots of leaseholders, and not all of them want that responsibility.
No.
Now, what's most common with share of freehold is that it tends to take place on smaller units. So maybe a conversion of an old Victorian house into maybe 6 flats. That typically could be share of freehold. And they have responsibility for the exterior of the building and the grounds around it. But when I speak to people that do manage those, the one person that tends to take responsibility over the others is responsible for accounting and maintenance and organisation, all that sort of stuff. It is a lot of responsibility. And if you take that model or similar model and put it in a high rise, I mean, that's a full-time job.
Okay, well, that sort of just underlines my fears about this. I mean, for instance, I live in a building where there are, I think, probably 600 apartments. The thought of a committee taken from those 600 people running a building as complex as the one it just frightens me to death. The laws, the responsibilities, the dangers of running a building of that type is a hugely professionalized job.
Yeah,
it really is complex. And you've got a further complication, especially in London, where in a building, again like mine, you probably find 50-60% of the owners are overseas, who are very quick to send in their letters of complaint about this, that or the other. But when they're written back to and said, right, well, it's going to cost this, that and the other, suddenly vaporize, and are only interested in the rents that they're collecting. So I see this as a hugely dangerous sort of situation. And I do wonder whether, this legislation will cater for this or not. But I would have liked to have seen in it that, okay, well, tenants can manage this section, this section, and this section. But as far as accounting, legalities, and safety, perhaps you need, or it's obligatory to have a professional company handle that. It may even start a new little industry, actually, of a sort of specialised property management team. But
that has to happen. That has to happen.
But it's not currently in the legislation, is it, really?
No, and I wonder whether perhaps they think about bringing it in for buildings that are over 5 stories and 11 metres.
Yeah, could be. I think they need to.
Yes, yeah. I mean, effectively what they have is the safety of lives of the other people in that building. That's a huge responsibility. It needs to be done and underwritten by a professional.
But you see, we also need to get away from sort of knee-jerk reactions to things. Now, I can imagine when we had the fire safety issues post Grenfell, for instance, our balconies had to be changed because they were wooden slatted, had to be changed to aluminium. That's fine. Our developers, quite a good developer, he paid for that, and the tenants weren't held responsible for that. So that's fine. But I wonder if a safety issue crops up, whether a sort of amateur team of managers would make the right decisions about who to call in, who to get the second opinion from. You know, I just don't know what the process would have to be.
Yeah, so there's enormous legislation now around any building that's over 5 stories or 11 metres. But clearly the same rules don't apply for those buildings that share a freehold. So this all stems from who's liable for remedial works. And what they have said is that, and Mr. Gove, who brought this legislation out in the summer of 22, did so with the right intentions. Every person, I believe, has the right to shelter and the right for it to be safe. So the concept is correct. What wasn't thought through at all is how it works in practice.
The logistics.
Yeah, exactly. It's flawed in so many ways. So you can have a relevant building, so a building that meets that criteria in terms of height. But you also need to have a qualifying lease. And if you don't have the qualifying lease, then as a leaseholder, you're not protected by any of this. And if there needs to be remedial works that are done, then as a leaseholder who owns a non-qualifying lease, you have to pay it.
Well, I'd better ask you what a qualifying lease is, hadn't I?
There are a couple of criteria. The one that I think fascinates me most is, even though this was bought in June 22, it was backdated to Valentine's Day 22. So that's the date in which all of this stems from. So if you are buying a lease in a qualifying building right now, above 5 stories or 11 metres, to find out or not whether it's a qualifying lease all determines the situation of the lease on February 22. And you are not a qualifying lease if you're a professional landlord, for example. So if the person who owned that lease on that date also owns additional properties, more than 3, and they're a professional landlord, then you're buying a non-qualifying lease. Right. And I guess the problem is, because we're now in 2025, potentially you could have had somebody sell after 22, someone else bought it and could have a new buyer going
inadvertently has that responsibility.
Yeah, absolutely. Yeah. And the person who bought it, say they bought in June 22, they wouldn't have had this advice, potentially. So the person that will be buying it now, they're not asking the questions of the current owner. They're asking questions of the previous owner to determine if it was a qualifying lease or not.
It's difficult. And again, transferring management to tenants. I mean, one of the things that is often overlooked is that if a freeholder owns one of these big buildings and the service charge runs out of money and services can't be provided, he is responsible to pay for those costs himself. He has to subsidise it. And that's under law, as far as I understand. Yeah?
Yeah.
Now, are those tenants who are going to step in and run the building are going to want to cough up if there's shortfalls through non-payment or disasters or unexpected items? Well, chasing round tenants to get extra service charge payments to cover unsupported costs. Well, good luck with that.
It's a classic, isn't it? I think leaseholders look at freeholders and think, well, actually you're profiteering. But a lot of people like paying for convenience. And you're quite right. I think that if it came to it and they actually understood the position fully and realised that sometimes they're making a loss in some of these things, then I think they would think twice.
Right. Now, Chris, my understanding is that none of these new regulations are going to be retrospective, save for the example that you've just given about qualifying leases, which does have a sort of retrospective perspective to it. Aren't we going to end up with a sort of two-tier good and bad lease system in this country, and particularly in London?
Yeah, I sadly think we will. We will have legacy leases that have not, for whatever reason, been renewed. And there is a lot of this leasehold reform policy that has the right idea and will certainly benefit leaseholders. And I do think there's lots that needs to be done to benefit leaseholders. But equally, we have new leases that will be part of the common hold tenure that will be extremely different to some of the legacy leases that will already be in place, and these buildings could be next door to each other.
Well, you see, I can see that the government will say, oh, it's okay, as soon as the lease runs out, you'll have a new lease and it'll be under the new legislation. That's fine. But over the last, I would say, 10 to 15 years, most leases on fairly large new build properties with multiple occupancy have been 999 years anyway. So you got a damn long time to wait, haven't you, until you get the opportunity?
Yes, exactly right. So the things that could prompt a change to the lease would be giving people the right to be able to vary it, would be purchases would trigger potentially the opportunity to change the lease. But you're going to need agreement from the freeholder.
Yeah, exactly. Who's going to say no?
So it would have to be written into law that the freeholder would have to make reasonable changes to accommodate the new leaseholder or a new lease.
But I think if I'm right anyway, most 999-year leases that have been produced by, I mean, there's a sort of regular set of conveyancers in London who handle a lot of the big developments. A lot of them will have the clause in there that says all leases shall be of the same format.
Yeah,
that's a particular clause. That's to stop this guy over here being able to keep pets and this one not, and you know, all the rest of the issues that crop up. So that's going to be very difficult in itself, because the freeholder, if he alters one, is probably going to have to send out 500-600 deeds of variation at not insignificant cost.
Yeah, and this is the bit I think that just hasn't been thought through.
No, it hasn't.
They come up with, the government have come up with a concept that sounded really good on the campaign trail, and I think a lot of people have bought into that around building safety and leases just in general. But in reality, it's examples like that which screams that it just doesn't work, because there would need to be a legal battle between a lot of the huge freeholders and the government to decide how this is actually going to play out, because I think in reality a lot of people will lose a lot of money.
Well, I mean, it's on your sort of thinking it through comment. I know when Gove brought in this business about, well, it was really activated through COVID, where people perhaps feeling a little bit alone or isolated. No, we're going to make it obligatory to accept pets in the building. And people say, no, it could cause damage. I don't want my property having pets in it. And he said, no problem. Just increase the deposits that you charge your renters. Well, he missed the point that there is a legal cap on the amount of deposit that you can charge on a rental flat or house.
Quite right. This is why there needs to be negotiation and a committee in place.
Collaboration.
Collaboration's a great word. There needs to be a group of people that represent all the different sectors in the coalface to say, actually, this is a great idea, but it wouldn't work like that. Have you tried it like this, or would you consider it like this? That'll be a better solution for us.
Well, as I said earlier, I'd be happy for it to work, provided that the key issues, which is safety, money, and security are handled by a professional company as a matter of obligation rather than just choice. I think otherwise you're going to have people making decisions who are not insured to make such decisions. So there's going to be no comeback, or it's going to be ineffective comeback on people who can't remedy it anyway. I think that's the issue.
Yeah, of course. And I think just one final point on that is just around property values. And I wonder whether the new concept will be a more valuable one, or whether the existing legacy concept will become less valuable.
Well, that's your type 1 and type 2 lease sort of situation, isn't it? Now, one of the other things, I mean, it won't be totally negative. I mean, one having dealt with a lot of overseas buyers over many, many years, the first reaction when you talk about leasehold, they say, "What do you mean I don't own it? What on earth are you talking about? I'm paying for it." So I can see that this sort of common hold idea would be attractive to an overseas owner. It'll be far easier for him to understand the concept. Mm-hmm. But again, whether he understands the responsibility that goes with that is another issue, isn't it? And often in these cases, I'm sure you're very used to it, but dealing with people by remote means, mainly email or through various electronic communication methods, it's going to be quite hard to explain, isn't it?
It is. And the most important thing for anybody purchasing, especially a new build, is to understand exactly what you're legally committing to, both now to protect you, but also in the future when you come to sell again. And I don't think people quite often understand, especially where there are conveyancers who are doing new builds en masse. It tends to be the advice is written in broad form, and the conveyancing is undertaken when the building is just getting out of the ground. Then some units start to be sold off plan, and then the building's complete and buyers come along and finish it off. But the advice is very much copy and paste, and that is quite a dangerous game, which is why a lot of people ran into trouble when they bought leasehold houses, because they weren't aware that actually it was a lease and the requirements around that. And Persimmon and others got into quite a bit of hot water with these leasehold houses, which is why the government are having to unwind them now.
Well, I sort of agree, but there's another issue here. And it's understanding the concept and reasoning behind leasehold in the first place. And the overriding reason for leasehold was to make it simple to manage and keep in a good presentational and safety format an estate, a building or a collection of buildings, and having the authority to do that. Because you can't go to each individual and say, well, look, you dig that quarter of the garden, you dig that quarter. These things have got to be managed. And the experts at this were the big London estates, I suppose, of hundreds of years ago. This is why it was introduced. And I think if we come away from that, I can see why the big builders wanted to keep leasehold on houses, because they could maintain the standard of the overall estate.
Mm-hmm. Yeah,
very simply.
Definitely one argument for sure. I guess the other issue is that there are plenty of examples throughout the country where the building has not been kept up to a standard that keeps it fire safe, for example, and that is, of course, resulting in some devastating effects. So I think that there will be a lot of people campaigning for this, and the reason for that will be that they think that the people that are in the building can manage the building better than it's being currently managed. In reality, or in retrospect, what probably should have come out as a legislation is that the people managing the building should do it better.
Yes.
In a lot of cases.
Yes, I think that's right. Chris, I do want to just refer back to an earlier programme that we did when we were talking about times for conveyancing. Have really got to a pretty unacceptable level in this country. I mean, for a leasehold, it can take up to 6 months, can't it?
Can.
Yes. Now, as we said in that programme, solicitors tend to blame the lenders for asking too many questions. Lenders will blame the solicitors for taking too long to reply to inquiries, and the vendor and the purchaser just get totally frustrated throughout. But I do wonder if the lenders have got a bit of responsibility here, but not perhaps in the way that they think. I think they're entitled to ask what questions they want, and especially when we have safety matters, it's important that they do. But it did spawn a whole new industry of what I would call cut price conveyancing solicitors. You can get your conveyance for 150 quid. Well, I'm afraid you can't do a reasonable leasehold conveyance for 150 quid. Well, unless you're on twopence an hour or whatever the rate is.
Yes.
It just can't be done.
No, of course not.
Yeah,
No.
you know, I mean, the old rule used to be probably 1% of the capital value, which, say, in London would probably see an average conveyancing fee of probably, I don't know, maybe £5,000 to £10,000. So how you can do that for 100 quid, I don't know. So I don't know whether the industry has almost shot itself in the foot a little bit there, because the private firm of solicitors are going to say, well, the building society are telling us that they use so-and-so and they're 200 quid. We're 2,000. You know, you make your choice. Well, where's a young couple going to go? They're going to go with £200, aren't they? You know?
Yes, of course. Yeah, absolutely. And these firms that are involved in over half the chains in the UK right now, turning over the highest volume, are doing so with very limited technical expertise. So a lot of them have sort of one conveyancer overseeing maybe 50 members of staff in terms of technical support and advice. And these are quite often the firms that are dominating Google. So a client would Google conveyancers in my patch and would get one of these, even though they're not local. And what would happen is the client would go to case manager 1 and 2 and 3 and 4, not knowing who they're dealing with. And these people quite often have gone through a process where they haven't got a legal background. They've probably worked in something like retail, come into the industry, been on a course. I've heard horror stories of as little as 6 weeks, and then be given a caseload of as much as 200 matters. Now, that's really dangerous. And when it's vanilla and it's straightforward and all the support is in place, it could probably work. But when there's something a little bit complex and you need to wait for technical support, the transaction delay is enormous.
But you see, again, perception is a key point here. I would guess that, especially with the younger generations, they would assume that conveyancer is a solicitor.
Of course.
And he's not, is he?
No, absolutely. So there are multiple roles within a firm. Traditionally, I guess, legal assistant, paralegal, solicitor, trainee solicitor. But you don't have to be a conveyancer. And that's what's really scary. So there isn't an awful lot of regulation around who is actually doing the work. So there are firms taking advantage of this, and we see on a regular basis advice coming in from people who have bought previously or are now selling a property that they bought where it was done incorrectly. On new builds specifically, we might act on the 20th unit, and the client will say, and maybe quite rightly so, oh, they've already sold 20, it must be fine. We quite often identify problems, and that's because perhaps it was done wrong first and the other 19 just followed suit. Not necessarily a deal breaker, but it's good to identify these issues to maybe indemnify against them so it doesn't cause the buyer an issue when they come to sell in the future. So yeah, it is a real concern that there are people operating at a very cheap, a very low level, especially when they're dealing with leasehold, because it is terribly complex.
Yeah. Chris, just sort of looking at the thing globally, what do you see as the good points of the Leasehold Reform Act, and what do you see as some of the questionable areas, let's put it that way?
I think there are lots of positives that are written down in legislation to benefit a leaseholder. Things like having more rights, having more ability to be able to challenge things, maybe not paying ground rent, not paying some extortionate premiums to uplift or extend the lease. That all makes sense. The flip side to that, and the bit that really concerns me, is the freeholders that are running these companies, because they are companies, are doing so possibly as an investment and have entered into that market to make money. And I wonder how they're going to make money as much if they get rid of something like marriage value or premiums.
If I just, for the benefit of our viewers, point out that quite often you get, especially with a big development, the freeholder will retain the right to manage, but he'll sell off the ground rent income.
Yes.
And that will go into what you rightly determine as a company, an investment company. So some of these investment companies, and the insurance companies are among these numbers, they have a huge collection of ground rents, huge income, risk-free, because you can't get better security than the ground rent because nobody's going to default.
Well, it's up there on the risk curve with government bonds.
Yeah, sure. So those companies are going to be left with an almost worthless asset that they've paid huge amounts of money for. Now, where does the argument come there? So where does the argument go? These companies are not going to sit there and say, oh, well.
This could be one of those things that sadly the government haven't thought through, because there could be a lot of viewers sat there at home right now with a pension fund, with a very popular provider, and not actually realise that they've got some exposure to this stuff indirectly. Now, the older you are, the lower down the risk curve you come, and maybe have bigger exposure to this type of stuff the closer you are to retirement. So it could be a concern for some of the big pension providers that have exposure to this stuff, but there may not be the regular income coming in that they once thought. But is it going to actually come to fruition is a very different question.
Well, again, at the start of the programme, we talked about when these changes are likely to come into effect. We were told it would be this spring. That was the deadline. Then that's moved to October, November of this year, possibly. We're then going to have Parliament's Christmas holidays, aren't we? So my view is it'll certainly be the new year at earliest. Have you had any feedback from the government on this as a firm of conveyancing solicitors?
We haven't had any different guidance to what's published publicly. My thoughts just go out to everybody either in the position where they own a leasehold right now and the lease is diminishing in term and they're thinking about, do I extend or wait? The ground rent's expensive. We're getting close to falling into marriage value territory. Or somebody looking to purchase one of these properties and thinking, do I buy now or do I hold off and wait for these changes to come into force? If the track record is anything to go by, I would say the time in which it takes to implement this stuff is going to be much later than everybody thinks. And are the big boys going to just roll over and take it? Probably not. And that argument could take some time.
So for somebody like me who's got, let me just think, 990 odd years left on my lease, I've got a bit of a long wait, haven't I, before I can see much change?
Just a tad, yes, yeah. Maybe the AI version of yourself later on down the line can challenge it.
My avatar.
Your avatar, yes.
Okay. Well, look, Chris, once again, thank you very much for coming in. Chris Barry is Business Development Director of Thomas Legal. Very appreciative of your time and your expertise. I'm sure our viewers will be eternally grateful to have heard your comments and advice. Thank you indeed.
Thank you very much for having me.
Okay, I'm Stephen Galpin. Join me again next time on Property Matters.